Several people on the agenda today, and I apologize for running late. This has been a crazy day as we get approached to the end of the session, and a lot of meetings going on, committee meetings. So with that, I want to go ahead and start. Again, we apologize for the delay. We had several or a few people on the agenda, and I want to know if they're here. Melody, is it Daring? All right, Melody, you're here to speak, and also Whitney Fuchs. All right, they all on the agenda, and so if we're going to go ahead and call the meeting to order. And Melody, if you would come up and tell us the issue that you've got going on. And Melody, so again, I want to remind the committee we're here to look at rules and regs and how they're burdensome on Georgia businesses. And Melody and Whitney to follow. One of the things that I think is very important for this committee is we've heard this. Help us dial in on where these regulations are. You're in your specific industries. You're dealing with it every day. A lot of us have different backgrounds, experiences. We serve on different committees. So make sure you try to dial us into, hey, here's our industry, here's the agency or department that we're answering to, and here are the regulations that we're having an issue. If you can, that would help us to focus in on your issue. So with that, Melody, welcome. And if you would, start off, tell us who you are, where you're from, and a little bit about yourself.
Well, thank you for letting me speak here today. This is an issue that's near and dear to my heart. My name is Melody Daring. Many of you may know me as a reporter. I've covered the state capitol for actually 20 years, but my husband and I have a catering business, Daring Catering, and that's why I'm here today. The business is located in Kennesaw, and we live in Cartersville, so it's primarily that area. I'm not here just to complain. I'm going to also give you some suggestions and things that we've learned over the past 10 years that we really think could help businesses. And it's my business, since it's tailored to the food service industry, that's the primary focus I'm going to be on, but I think some of these suggestions could help all businesses. The one thing that we need to change is that small businesses are designated as 10 million and under, but most small businesses are really, especially in today's economy, are micro businesses. We're a micro business, but yet we have to fulfill all the regulations of a $10 million business, which makes it almost impossible to survive. And I think that needs to be changed. You think, small business, 10 million, this group that helps envelop all of them into a secure fashion, but it hurts micro businesses. There's at least 5 people I know of right now that have small businesses that will not develop them more than past a hobby because they don't want to go under the regulations. And these are businesses that could hire 2, 3, 4, 5 people and do really well. They have to turn down business because they don't want to go over that dollar figure that separates being a hobby from being a business. And you need to make it where they see the benefit in expanding, rather than, if I expand, I'm going to be regulated to death and I won't be able to survive. I think there needs to be a distinction between micro business from small business in offering lower regulations, lower fees, and lower fines for some violations than under the small business designation. This should apply to every state agency that deals with business permitting and licensing, from public health to workman's compensation to insurance requirements to the state tax commissioner's office. Related to the food industry, there's several things in the public health policy that needs to be changed. The way public health and the State Department of regulations are right now, they're not really about public health in food. It's about money. For instance, there's exemptions for nonprofits and festivals and churches, and I'm not saying regulate them. I'm not saying that at all, because there's really not a problem with it. But it shows that if there's so many exemptions for people that don't make money, but then you have all these regulations for people that feed far less people, sometimes 30 people a day for people who do make money, then obviously the gear of the regulations isn't public health. It's who's making the money. And that's what you have to change. You have to take the money factor out of public health and truly make the regulations more about public health and food safety, rather than they're a nonprofit feeding thousands, so they don't get regulated. They're a small business feeding 30, they get regulated as if they're a chain restaurant. There needs to be some working in there for the smaller person in accordance to what they do, and truly make it about public health rather than about whether it's for profit or nonprofit. The other problems with public health, and now I'm going to get into some nuts and bolts that I think you guys want, is that the public health state rules vary from county to county. The state has their rules, but each county gets to designate how they interpret and how they apply them. And those rules are constantly changing. A case in point is with the mobile food vending. Back 4 or 5 years ago, mobile food vending, a complete kitchen, I'm not talking about a trailer, I'm talking about a complete kitchen in a mobile unit, was considered a kitchen and could get public health certification. But then the law changed, saying you had to have a base kitchen to have a mobile kitchen, and you couldn't cook in your mobile kitchen, you had to cook in your base kitchen and only warm it up in your mobile kitchen. This is state. The state has gotten involved in this. Now, this primarily affects Atlanta, and I'll tell you what happened. This gets back to the money issue. These mobile vendors, see, to open a facility where it's catering or a restaurant, and that's another thing I'm going to get to in a minute is about catering, it costs about $200,000 to really open a restaurant or anything to deal with food service because of all the regulations. So people decided to get, and we were one of them, we almost did it and we didn't, but to get a mobile unit because they could get the public health certifications if they have the proper sinks and the proper refrigeration, and that would be much cheaper because that's about $15,000 to $20,000. So people start getting the mobile units, and they would go down to Atlanta and made a lot of money. The restaurants in Atlanta got upset. So then they changed the rule that if you have a mobile unit, you also have to have a restaurant or base operation. And then they said you can't cook in your mobile unit. You had to cook in your restaurant and just use the mobile unit to warm it up, even though the mobile unit is a fully serviced kitchen. Yes.
Let me make sure, and I want to make sure of this because this committee heard testimony last year. If I'm not mistaken, either the city of Atlanta or Fulton County somehow years ago got an exemption from the state, all the state rules, and they may, and this was a question we had last year, they may have their own set of rules. Are you familiar with that, or is that,
well, I am familiar with the situation in Atlanta, but we live outside Atlanta, and these were the rules we were told that were state rules. And in fact, I think legislation may have passed last year about the base unit for the mobile food vending, because we were researching a truck, and then when we said, oh, the rules are going to change, so we didn't do it. And then the rules did change. So then we ended up we're actually with the Edge Kitchen in Kennesaw, which is a wonderful program, by the way, and to have a base kitchen. So we are not in the city of Atlanta, and we were told these were the state rules. So, and I know that legislation actually passed last year or 2 years ago regarding mobile units and all this legislation.
Does that include like hot dog carts? And
It can be, but it can be gourmet food too.
okay, so hot dog carts fall into the same.
Hot dog carts fall into the same thing as everything else. So that's one of the problems. And then here's where the other part gets tricky. Even with all those regulations, the movie companies, with all the film credits, they're coming in now, they're bringing their own caterers from out of state. They have fully functioning commercial kitchens that are somehow exempted from everything else. So while we can't go out in our mobile unit and do as a fully servicing kitchen and do food without a base kitchen, the people from California can come into the state on their fully functioning kitchens and provide food for the movie sets.
And that may be an issue of private versus public.
That may be, but the rules, you see where the rules are getting very murky. This is the problem that we have in our industry because we're not sure where we fall. And to be honest, no one in the state is really sure of what rules follow where. And so there needs to be some consistency there, and they need to at least be stable enough, because if you make an investment, a $20,000 or $30,000 investment, you want to be able to recoup your investment. You don't want to change the next year where you can't use what you just bought.
And I agree. I I love the cooking channel and seeing. I know that these mobile kitchens are becoming more popular, and like you said, it's just not a hot dog stand. It's folks are very specialized in what they're serving, and so.
And that's one of the big things. There also needs to be a distinction between catering and restaurants. Under the public health law, the way it is now, a catering company is considered a restaurant. So we have to have everything a restaurant has, but here's the distinction. Catering companies primarily have 2 seasons, March through June and September through December. So the problem that presents with public health is that in July you're basically not functioning, so everything is turned off, you don't have any food, and also you buy food pretty much per event. So when they come to do inspection and everything's turned off and you don't have any food, if you have a standalone facility, that presents a problem because they're treating you like a restaurant. So that you need to have a separate category. And also in the state law, it doesn't allow for other catering things like coolers and hot boxes because we transport food. Under state law, you really aren't supposed to transport food, and unless you have a refrigerated truck. Now, if you're doing a catering event for 30 people, you're not going to have a $50,000 refrigerated truck. And and there's really no need for it because you have food safety with the coolers and the hot boxes. They do not lose temperature. But even in the state law and public health law, they don't know how to inspect them because it's not even listed in the law because they only list as a restaurant. So that's another issue. The other thing regarding the health violations, and this was a particular problem during the recession, is there's no appeals process and there are no warnings. A health inspector can come in, and it's not all food related either. They can come in and not see, not like the way something looks or it's not related to temperature and fine you, and you have no appeals process. And during the recession, a lot of restaurant owners were saying that they were doing this, that they were getting repeat inspections to generate money for the state because the state was in a deficit. And the restaurants hadn't done anything differently than what they had done in the past. And where in the past they'd gotten high scores, but they would come in and be a little bit more stringent because that was a money generator. That did not happen to us, but I know it happened to several people at that time. The other, and this is a point of problem too, counties do not recognize other public health certificates in other counties. And when you have a catering business, and like we are in Cobb, we do business in Floyd, in Cherokee, some in Atlanta and Fulton, all over. And when I call to make sure it's going to be okay for us to come there, they say they do not recognize our health certificate. And they want to have another inspection when we get there to give us a temporary permit for the one event, not continual events, one event, which is $150 to $200 for one event. And we have to do that every time. I think if you have a food service certificate in one county, it should be recognized in all the counties. That just makes sense. But it's not, because each county, even though it's a state laws, each county regulates it themselves. So that's another issue that can be changed. Then I mentioned about interpreting state laws and so forth. That's somewhat of a problem for caterers because it's not really consistent. And then, and I mentioned about the movies. It'd be nice to have encouraged to use local people, but you can't force that, obviously. I'm going to go quickly through 2 other very brief subjects. One is employee workman's comp issue, and the other is tort reform. Employees, under current law, an employee, and this affects all businesses, not just ours, an employee can lie on the job application, and it means nothing legally. For instance, they can lie about their health and say they have a back injury, say they don't, then they later on get hurt. The employer is still responsible, even if they didn't know. And in our case, we had an employee that did that, and she did it solely because, and she admitted this, because she didn't have insurance and she wanted help for a chronic back problem. She didn't tell us she had it. She did not fall. She just said she slipped a little. It cost us $20,000. And it ended up settling where we gave her $1,500. And that, there's some things you can do to change that. This is based on a concept. The employee state labor laws are based on the concept that employers are evil and employees are always good.
Did that go through the EEOC or did that go through?
She actually sued us individually, which is another point, and our workman's comp. She failed twice. She slipped her foot once, sued us individually. Then she fake fell again in front of people and sued workman's comp. And she settled for $3,200 workman's comp and then $1,500 for us. But it cost us personally, beyond workman's comp, $20,000 to defend it. And as it turned out, she had and we did a background check and it didn't show up. As it turned out in our investigation, she had a criminal history, financial fraud, insurance fraud, and all this stuff. And we had no protection of it because it costs more to take her to court than to settle. Now, but there's some things you can do, because this happens all the time. Employees get hurt playing softball on Saturday. They come back on Monday, workman's comp. Okay? So there's some things you can do about that. And it's just tightening up the rules. Because one of the rules is they're supposed to report an incident immediately, but under the state law, they actually have 30 days. And that's a little bit of a problem. Here's my recommendations. Employees that do not disclose past injuries or chronic problems on their application are not entitled to workman's comp benefits and lose the right to sue. Employees who do not immediately report work-related incidents to their employer lose the right to sue or workman's compensation. Employees reporting work-related events are required to go to the employer's doctor and are required to take a drug alcohol test. Foregoing either of these, because a lot of employees will say, I'm okay, I'm okay, I'm okay, and then they come back later and they sue you. They just don't want to do the drug test. Should forfeit the right to workman's comp and the right to sue. And then all criminal backgrounds should be immediately available to employer, their attorney, or insurance company for a nominal fee as public records in the event that a workman's comp case or lawsuit is filed. And this part is key. There should be a state database in the insurance office of every employee who files a claim or such a lawsuit in Georgia where a proper investigation can be conducted on repeat filers. Because this particular woman had done it 5-6 times. She'd find a new business, get hired, her background check comes up clean, she would do the same thing. That really needs help. And on tort reform, the main problem, and it's just some tweaks in the law really, is that even if you incorporate in the state of Georgia, attorneys can sue you personally. They're not supposed to, but it costs you, if they sue you personally, it costs you about $10,000 to reverse it. So it needs to be, it can be fixed in the courts with a simple clarification that any commercial case must be filed only against the company to be valid in court. And then the second thing is any lawsuit filed in Superior Court against a small business or a micro business, this would be key, should first go to a judge to determine merit. This can be done in briefs, in formal court hearing. The way it is now, if you try to get a direct verdict, it may or may not work. You have to go through mediation, the whole court process, and I will tell you it costs $20,000 to $30,000 even to get to mediation. And that involves landlords. Again, I'm not even talking about products. I'm talking about true civil issues of landlords, rents, those types of issues. And if we had a landlord issue that cost us thousands of dollars, and we didn't have to end up paying him anything, but it cost us thousands of dollars in attorneys. And had we had an ability to go before a judge and show what we had put into his building, the judge would have said, this is ridiculous, because the lawyers looked at the lease and said this is ridiculous, but we still had to go through the process. And those kind of things are what put businesses under. It almost put us under. And it certainly distracts from the business. In short, there needs to be some type of protection for these small businesses and micro businesses from people that are out to, I don't say scam, but they are. And there isn't any right now. There is none. All you can do is hire a lawyer, and they say, give me $30,000, and I'll take this on for you. Well, for most small businesses, they don't make, when they start out, they make maybe $10,000 a year. And they usually are people that are out of work that try to start a business. They invest their savings, their retirement. And truly, I think most of the reasons that businesses fail, they talk about mismanagement of money and different things. In my experience, the reason why most businesses fail is because they get so tired of fighting the state and regulations, fighting code enforcement, fighting attorneys for people that want money out of them, and employees that want money out of them, and they just give up because they're like, it's not worth it. To increase small business in Georgia, we need to make it worth it, where it said, we've got your back. As long as you're doing the right things, paying your taxes, filing what you're supposed to file, obeying the rules, we are going to protect you from people that want to cheat you. And that is truly the way it needs to be. And it does involve a lot of lengthy legislation. It just involves some tweaking of some current laws that we have in many of these cases and looking at it overall. That's what I have to say. That's basically all I have. I appreciate the opportunity to
Melody,
address these.
we've got some questions.
Okay.
So if you don't mind, and
I don't
I know
mind.
there was out in the audience had I guess maybe a comment. I'm going to recognize her in a second. I'm going to get to the committee members, and then I know you look like you had a comment about testimony here. So if you'll hold off, I've got you, okay? First, 27, is this Representative Kendrick?
It is. Thank you so much. I'm a business attorney, so I think I can speak a little bit about the litigation part of it. My firm actually doesn't do litigation for this very reason, is because small businesses really do make up the backbone of this country, and it is so expensive to go to litigation. I'll only charge you $10,000, but the point is that that's a discount. But the point is you're right. Attorneys do ask for a lot up front, and it can just really drown a small business. I think some of the things that you said are very, very true. Some of the things, I'm gonna be totally honest with you, I am certainly not in favor of, but I think you raised some good concerns about small businesses and their ability to be able to operate, because litigation is so expensive, and sort of finding a balance between businesses being able to operate, but at the same time protecting employee rights as well, because even though I'm a business attorney, I do care for employees. So just thank you so much for that, and I look forward to other questions from the committee.
Thank you. I think Representative Dudgeon was next.
Thank you, Mr. Chairman. I actually want to make a motion we send her to Legislative Council to get a bill drawn up. But a serious comment. I spent 2 weeks in October in Hong Kong and mainland China. First time I've been to Taiwan before. And one comment I want to make, your thing there was a small business person on every square inch of the big cities in Hong Kong and China. So I'd like to point out that in a communist country, I believe it's way easier to start a small business, as ironic as that is, as in the United States. And I think I really appreciate your testimony, because you had very specific things, and especially the county by county thing. We have state reciprocal agreements just for that reason, just to make it easier to do business. And there's especially no reason we should have different counties, especially in the metro area, making it difficult for you to do business. And I personally have known, I've struggled through my small business and made it through the frustrations, but the 2 or 3 friends who just quit, they're like, I'm done with this, just too much hassle. So thank you very much for coming.
I think Representative Harden was next, and then Representative Peasold.
Thank you, Mr. Chairman, and I apologize for being late. But there were a couple of things that I was interested in, and you said something about it, and maybe our lawyers can answer this question. Can we negate a person's right to sue?
I don't want to negate a person's right to sue, but what I would like to do is to find a way to where they're not lying to sue. For instance, the whole application on ours, it said, because our employees had to be able to lift 50 pounds. Do you have any injuries that would prevent you or cause you harm to lift 50 pounds? This particular person said no. Come to find out, she had a previous back injury. while I sympathize with that, I don't feel it's right to make the employer responsible for a back injury they did not know about, that she, in fact, had lied about. That's where the middle ground sort of comes. I understand why you have employee rules, because you do want to protect employees.
Yeah.
But most small business owners don't want to hurt employees. And when you talk about real small business, micro business, and they just want to be able to do the work and have employees be honest with them. And so you have to somehow put accountability on the employee for their injury. For instance, accountability to report something immediately when it happens. In our case, she didn't. We found out about it when 2 days later a doctor's office called and said she's in here with a back problem, saying you have workman's comp. And that is the kind of thing we need to put a stop to.
All right. So, but I guess what I'm after, is there a way in the hiring process that you can solve that if and I still don't know whether we can say to a person you can't sue. You can.
Yeah, I mean, just put it in an agreement.
Yeah.
I mean, that's what my.
Yeah. Well, and that's what
And it-
but it wouldn't be something we could do.
No, not something.
Yeah, okay, that not in law,
Well, but
but if, and the other thing, I was wondering if you could put in your agreement is that, I have not been involved in any legal action within the,
You can, but what has happened, what a lawyer told us, and maybe Ms. Kendrick, and it's good to see you again, by the way, has told us, even on the application, I thought the application was, in fact, a legal agreement, and they said application doesn't matter what she writes on it. It
All right.
doesn't.
Who said this?
Our attorney at the time, during this particular case, I said she put on there, she hadn't been convicted of any felonies, which she had, that she didn't have a back injury, which she did. And I said, can we use that to our legal advantage? And he said, it doesn't matter what's on the application. And that's where the state law can change, that an application, in the application paperwork, to make sure that it is a legally binding agreement. Maybe Ms. Kendrick can.
yeah, well, we
address
could do
that.
that, but could she also do that by having it notarized and sworn to?
Put a provision down at the bottom, making it legal. This says that this is a binding contract and everything you have in here is true. Just add 2 sentences to it.
Yeah, and that's what I'm trying to get at is what do we need to do, and what could the business owner do? And I was in business for 26
Right.
years, and I also was mayor for 8 years of a small town, and I know about the workers' comp injuries of which you speak. I had a lot of folks get hurt on Saturday night and and reported it Monday morning as a work-related accident. So I know that type of thing happens. But really what I was trying to get at was what could you do, to protect yourself, and what do we need to do to protect yourself? And
Some of those things, I'll tell you what we have done, and you probably won't like this answer. We don't have any employees. It's my husband and I, and we hire employees through a temp service because
Yeah.
they have all those things in place. Or in some cases, we do subcontract work, mostly with our chefs that have their business, which has their things, because then we sign an agreement that they're responsible for their own taxes and their own insurance and all that.
Yeah.
So those are the 2 ways we do it. It would be nice to be able to have employees and know, and again, I'm not sure, because from what I've been told, even though you put at the bottom a legal agreement and all that, they still will try to sue you. And that cost, it needs to be some kind of protection that if the business owner has done their due diligence and has these legal agreements in place that we've spoken of, that somehow that does protect them at least to some degree in some way. And that's where the state can make a difference to make sure that they are protected if the employee does sue them, to have I don't say cheaper process, but a cheaper process so that you don't have to give up your whole life savings to defend on one thing. The other thing, and I mentioned it briefly, that would be helpful is to have a state database of repeat filers. because
And I want to get to that.
that would be very helpful.
All right, let me make one other quick question, Mr. Chairman, if you don't mind. And I was wondering, in your particular business, where you have to buy a temporary certificate across county lines, would it be feasible to buy a basically business license in each county that you
No,
serve?
no.
That cost is too high.
The cost would be too high because some counties are higher than others and all that. Our business license right now is about $85, $86. Even if you go the cheapest one, if you do 10 counties, that's $800, $900. And then you would have to buy a public health certificate in every county. That's $200 a county.
Yeah.
You're talking about $2,000 or $3,000, for an upstart business. Whereas right now we're just kind of getting rebooted in a way in our new kitchen. So I can't guarantee that we're going to bring in that much.
Okay, thank you.
So that's unfeasible.
Representative Pizzola.
As a fellow restaurant owner-operator, I completely sympathize with everything that you're talking about. I can't tell. We could probably sit in the back and talk shop for hours. I can't tell you how many times I've been on a hearing with the Department of Labor, and I have to wonder, whose side are you on? I had to fire somebody for stealing from me, and they said, well, are you sure that the person knew that stealing was against company policy? Well, yes, they signed the code of conduct. Can you prove to me that this person understood what they were signing when they signed the document? You couldn't possibly make this stuff up. And that's why I'm really proud to be on this committee, because it is a burden. And we're not a startup company anymore, but you're right. Your first comment was people want to just do this as a hobby because it's just not worth it. And there are days, and our company is fairly sizable. I mean, it's not a micro, but there are days when we just want to throw in the towel. I mean, it's just not worth it. We need to make it easier for the entrepreneurial spirit to foster in our people. That's how wealth is created. That's how jobs are created. And I feel like we're letting the bad employees ruin everything for the good employees and the good employers.
That's
So
true.
I echo what you're
because
saying.
there's a lot of people that just don't want to hire because you have so much confidentiality now. Even if you do a criminal background check, it doesn't really show anything. And if you call someone to get a reference, all they can really say is they worked here.
That's
And
right.
it's hard. You really are going on faith to hire an employee. And our basic policy, we got 3 people we would love to hire. And if we grow this summer, we probably will. But we've known them for 4 or 5 years. We know their family. That's the way we hire, because we have to know them and know what they're about before we can't take someone off the street. And that's kind of sad because there's a lot of people out there who need jobs.
You can't take the risk, the unknown.
No.
So, thank you, Representative Pizzola. And is Representative Jackson at the end?
Thank you. I guess my question was directed toward Representative Kendrick. If the person misrepresented everything on the application, they had a pre-existing condition, as this person obviously had. If it's found out that they had the pre-existing condition, can she come back and sue that person because she spent so much money?
Well, usually, and granted, I don't go to court much because I do transactional law, but when I was a civil litigator, usually, her application would be something that she would show during the course of whatever trial is going on, use as a defense, as opposed to letting it get to judgment and then trying to go after. Because then you have this very archaic law that we have in Georgia that you can't go back and relitigate something over and over again. So you have to do it during the course of that actual case.
But it seems if she spent that much money and the person lied on the application, there should be some recourse for her.
Well, the recourse would be that hopefully whoever her attorney was presented that as a defense, and it never got to that point. Because afterwards, it's hard to go back and
The reason why it doesn't get to that point is because it costs $10,000 to take it to court versus a settlement. The settlement was $1,500. And what I would love to see, and I'm not real sure how this could work without messing up everything, and I don't want you guys to mess up stuff, but is to get it to where if a case is like, if you had a legal document like that, you could show it off the bat and avoid having to at least take the long route through court and mediation, maybe send it straight to mediation or something to where you don't have to go through and spend $20,000 or $25,000 to end up mediating for $1,500. And I'm not sure of the constitutional element of
yeah,
that.
that is something that I think we, it's not only your business, all businesses.
Right.
And it's this litigious society that we're living in. And it's, I think people use the law, like you have said, to get at possibly some kind of payday. Okay? And, I think this body is trying to do some some tort reform before the courts have thrown back. It's very difficult, but, in my mind, we need to make it punitive. If you bring something that's frivolous, you need to think twice. So it needs to be more.
Don't have any money to go after. So
Right.
it's hard to sue
Yeah.
them because
Well-
if you win,
Well,
throw good money
yeah,
on the
it
Well,
is.
in our case, my husband and I had personal money. The business really didn't have any money because we were a startup. But we had things. But we had personal money, so what they did was, even though we were incorporated,
Trying to break the
they went down
corporate
personally.
bill.
And so we had to fight personally as well as through workman's comp or through other attorneys for the business. At one point, we had 12 attorneys.
And
Okay,
here's what
so-
here's what I think you bring some interesting things to the table. And real quick, I'm going to ask you to stay right there. I know there was a young lady in the back. Would you mind if you've got a comment or?
I just wanted to, I'm Kimberly Stringer.
Will you stand up for us, please?
From the Department of Public Health, so I
Yeah.
just wanted to let you know and the committee know that we are here. If you had any questions, we can exchange information, help answer some questions, and definitely make sure we got notes down for all your concerns. We definitely want to address anything that's making this more difficult, but also answer some questions about why counties may be different or what permits, why permits are different for nonprofits and things like that. So in our food service strategies.
I appreciate that, Kimberly, and you bring up some points, Melody, that I think are valid points, and it's this is the second or third time we've heard testimony regarding public health and regulation from folks who are trying to run restaurants or catering business. I think this is an issue. I'll address the small versus big. As a CPA, after Enron, everything got so complicated, okay? And you had to do so many things to, the CYA is a polite way to put that. But as a smaller certified public accountant, we had smaller businesses out there that never had the sophistication or the size of the larger corporations, but the rules and regs still applied. At our level, when we went in to do audits, the procedures applying across the board, no matter what size or sophistication your business is. That's a balance. I mean, there are issues, and I would say a small company can mess up just as big as a large company can. But I see where you're going with this. We've set rules out to cover everything under the sun, and sophisticated businesses or larger businesses, as you say, the micro versus small or large, and that's the first time that it's been articulated in testimony up here, and I appreciate that because I think you've brought out a good point there, something that's intuitive to us, but something that as we go forward, and as we hear finished testimony, I'm going to talk to the committee about what we're probably going to do over the summer and some things we're going to do to bring in the next session. But I appreciate that point that you just made. That's something I think this committee needs to look at. County versus county, I'd be interested in talking. Kimberly, I'm sorry. I would say from a larger point of view, and again, I go back to, as we have rules and regs, people want uniformity. Okay, we may hate the rules, and we do need to chop them down and bring them into size. But people want clarity and they want uniformity. And when you have to go into one jurisdiction and there's one set of rules, and then another jurisdiction there's another set of rules. Again, this is where we've got to start looking at how we do things. And I don't want to, we've got this thing of local control, that's fine, but I would also say that, the governments, the local governments are an act of what we created, the legislature. And I don't want to take that away, but we've heard testimony before about different rules in different counties. And so here's a business person that may be operating over a region, and they've got, it takes the majority of their time to make sure that they're following each rule in each county, or they're going to walk into a trap. And I think that is something. Uniformity is very, very important, especially what we've heard with the restaurant. Mm-hmm. And Kimberly, I think you're shaking your head that there are some, the local governments have some autonomy, or would that?
The way public health is set up, so we have our state office in 18 districts.
Mm-hmm.
And those districts, all of the counties have their own public health, board of public health. These set the rules. They then have to, the rules are the same for all the counties, except for Fulton. There's the one exception for Fulton because they meet a certain population size. We don't have any control over Fulton.
We may have to discuss that. What's good for the goose is good for the gander. I mean, but again.
Yeah, and that's not our, I mean, that was something that's in code. I hear that's being discussed. But the way that they enforce them is at the county level. So I'm being way more strict, but that's not something at the state we do. We're right that it should be the same.
And that goes into us. That goes into us about interpretation.
Well, interpretation, though. I mean, you've got so much interpretation. So,
But you shouldn't have to go to every different county. It should be one comprehensive rule, because there are a lot of mobile businesses. It's not just catering.
But that's right. And again, we shouldn't be doing things to generate money. Government should not be doing things to generate. If it's the purpose of protecting the public, then money is an issue. That's not just in public health. It's in a lot of things that we're seeing right now. I would ask you. You've brought up some very interesting things in regards to workman's comp. Okay, that's something that this board, this committee heard in last year's testimony. It's something that I would very much appreciate whatever you could share in detail in regards to your situation as it went through this process. Mm-hmm. Workman's comp affects not only your industry but every other business in the state of Georgia. And you're right. We're seeing in this committee, we've seen testimony numerous times of where the employee is trying to take advantage of the employer. Mm-hmm. That's a large cost, guys, to businesses, is when somebody's being dishonest. And that's a very tough nut to crack, but that is one of the things that I'm going at the end of this testimony, I'm going to sort of give some direction of where we're going, but I want workman's comp to be at the top of the list. And if you could, Melody, share with us and leave with Jason here contact information, but also if you could get to us the detail of what you're willing to share in regards to that case, this committee would be very grateful, because we want to start looking at those issues.
Well, I have details because I take notes every single day this happened. I'm a reporter by trade, so I take a lot of notes. As a business owner, and I will be happy to share details, email, and all that, because some of it can be quite lengthy. Is that we went into business wanting to do the right thing all the way across the board, wanting to treat our employees right. We were determined. I had very good bosses working where I worked, and I was trying to model myself after them, to treat employees like family, to do the right thing, to help them out. And in this particular case, it was a woman that we had hired, and again, I checked her resume, I checked where she worked, did a criminal check, nothing showed up, even though we found out later she'd been arrested at least 15 times after we got investigators involved. Because of the situation with the landlord, we had some issues moving in. So we got moved in July, and as anybody's in the restaurant business can tell you, July stinks. You don't have any business in July. So I didn't really work my employees. They were on the books, but I didn't work them. So I was trying to work out some issues about workman's comp and those kind of things while we were in this transitional phase. Okay, so we worked a party Nobody saw her slip. Nobody saw her fall. She didn't tell us. 2 days later, we get a call from the doctor. Said she fell that Saturday, and she'd hurt her back. She had talked to another employee, to get her to vouch for her. But then during testimony, she said she didn't really fall. One foot sort of slipped, a little. And so I called her in after the doctor's visit. I called her in and said, "What's going on? How come you didn't?" Because we had a big sign, "Must report." And she said, "Well, I don't have insurance. I hurt my back several years ago, and I'm out of pain medicine, and we also found out later she had an addiction, and I need some pain medicine." And I said, "You know you can't do this." And she said, "That's what workman's comp is for." And I said, "No, it's not." She said, "That's what workman's comp is for." And I said, "No." What she ended up doing, because and this was my mistake, our workman's comp, I had signed the papers, but the check had not gone through at that point. She called the workman's comp board. They came down and they fined us $500 because the day she said she fell, the check had not gone through. So we take
that's what. And again, I know. I would like for you to summarize that so that we can put this on the record. And I think at the end of this, I'm going to give some direction as to this committee. But that's what I want you to put on, if you can, supply us with detailed records about this.
I will.
And I think this is something that this committee will start to look at, and it's something we identified last year. So with that, one final question, because I know we've got one more person that testified. Is this Representative Pizzold? Are you? Yes, Mr. Chairman.
To the young lady from the health department, is there some kind of at-a-glance grid-based form that we could see to compare by county what the differences are in health regulations? Because we operate restaurants in 5 different counties.
And I'm sorry, Kimberly, your cohort here, director?
Yeah.
Identify your name.
My name is Cameron Wiggins. I'm the food service program director for the state of Georgia.
Okay.
Basically, to answer your question, we have one food service rule and regulation for the state.
Right.
The counties actually permit food service establishments. They actually do the enforcement. We interpret our own chapter. So take, for instance, we have an interpretation manual online that interprets the chapter. So I can provide that information to Mrs. Daring at the end, and she can follow up on that, and we can stay in contact to determine what's going on. I don't know her actual specific.
But what sort of regulations would differ from?
Well, the regulations.
So they are uniform.
Yes. Now, with the exception the chairman made earlier about Fulton County.
Sure.
They did make their own rules, but they choose to follow the state rules.
Okay.
Now they can interpret their own rules if they.
Okay.
But as far as now, I'm not sure if she's talking about permit or if she's talking about actual enforcement or because we write our own rules and everyone the county might adopt the rules.
Okay.
As an order.
But counties, to your knowledge, do counties have reciprocity with neighboring counties?
In terms of the rules.
In terms of the if you're permitted in this county.
And Representative, that may be something that this committee wants to look at. If you're certified in one county and there's one set of rules, okay, why is that not good for the next county? Okay, again, you bring up a great point, and it's uniform. How do we stop this madness? And obviously, while there's one set of rules, the outcome and the judgment, the interpretation, and then the enforcement of this, there's different outcomes. So why?
And by doing so, how do we encourage people to take risks, invest?
So, Representative Pizzold, your background and experience may help with this industry and
be glad to help
and field. So
sure.
Yes, sir, Director.
I would like to bring up one point. The food service permit is issued to a fixed location. That's what the chapter is based on. It's based on the FDA food code. And it's looking at controlling for protecting public health by controlling the minimal amount of controls to control the dispatch of foodborne illness. here talking about mobile food service, because as a caterer, she would be permitted in the county in which her fixed location. So I'm not sure if she's discussing mobile food service, whereby which she'd be permitted in the county in which she would have a fixed location, but she would also be permitted in each county in which she chooses to operate. That being the case, we have to be able to know where a food service establishment is operating. Otherwise, there will be no.
Well, maybe we need to look at that, and the catering does, as Melody has described. You know, there's nuances, and certainly in whether it's catering or this mobility issue of these mobile kitchens that are very sophisticated in nature. I mean, so again, committee, I appreciate you brought, you know, again, the second or third testimony that we've had in this committee in regard to this area, and I think you brought some good points out. I think this committee is going to stress one of this as an area. So, and Director, thank you, Kimberly, thank you. I know that this committee may afterwards have some questions for you, and certainly I'd like for y'all to leave your contact information with us so that we can get in touch with you. Thank you. Again, you've made some great points. Thank you so much. And the next testimony, Whitney, and again, last name? Fuchs. Make sure we say that right, Whitney.
Yeah.
Whitney, if you will, tell us a little bit about yourself and SBADD.
Okay, my name is Whitney Fuchs, and I'm the executive director of a nonprofit here in Atlanta. We work with people with developmental disabilities, and I'm also part of the association board for Service Provider Association for Individuals with DD. That's what SPAD stands for. And I testified last year, and I brought in the stack of papers this high, the regulations that our industry has to survive under. And it was interesting because subsequent to that, the Department of Behavioral Health put all the regulations online in a searchable database. Unfortunately, what they did was they took off the linear ability to read through all these, and now they put them online in a searchable database. So you had to go in and print out each page. So it certainly stopped the 1,200 page document because it was impossible really to go through and print out every page. It's kind of disingenuous to say, hey, we eliminated this policy manual. All we did was we put it into a database. So that was kind of a problem. And so we haven't had a change in leadership in that department, which I like Frank Berry. He's an old friend of mine. But what we saw this month, or actually the month of March, is that the department has let an RFP out to rewrite their policies and procedures. So what we have is we have a department that kind of, when we were asked to kind of move those policies down, they couldn't do it. They actually grew every time they did that. And then they kind of created another problem for providers. How are you going to read a policy manual? At least you could read page and page. And now you have to search, and you have to know what you're searching for in order to find it. So they're now going to set out another RFP to try to resolve this. More money wasted that could be going to services. Another issue that we face is that there is no fiscal note required by either HFR or the Department of Behavioral Health when they create new policies. And one of the challenges is that I'm a nonprofit head, and I raise a lot of money every year to offset the costs of what the state doesn't pay for the people that we support. There's a lot that we raise. And when we get to the situation where the state wants to see an investigation of everybody that goes into the hospital for a health issue, I have to employ my quality assurance department, who are non-licensed medical personnel, to investigate why a doctor has asked for somebody to be admitted to a hospital for a medical procedure. That was a simple policy change that was made in spring of 2011 that has cost me the additional 2 staff, FTEs, just to accommodate the volume of individuals that go into a hospital. Those are people I care for, and not even just in a residential model, but in a day program. They might be coming to the day program, and they need to have an investigation on them. It's absurd. We're investigating what our medical hospitals are admitting people. We have no control over the decision of a physician to admit somebody, but we have to investigate that.
Real quick, why was this put in?
I don't know. I was told last week that they've decided that, yeah, it probably wasn't a good policy and they're going to change it.
Could you give us, before you leave, the specific section so we don't have to go into this database and
I will
and
go
find
ahead.
it?
I will send it to you.
That would be great.
I will send it to you. So, every provider is in a situation. We take on a number of really challenging individuals, some of whom came out of institutions, some of whom are medically fragile. We work with a young man who has been hospitalized on and off 7 times since the first of the year, and he has significant seizure disorders. He lives with an RN. But every time he goes into the hospital, we have to do a full-blown investigation. And so that's 7 investigations. These are not easy. They take about 70 to 80 hours because everybody that's involved with that situation has to be interviewed. My staff have to go out and interview people. This is a problem. It's an absurdity of delivering services. So instead of providing charitable care, which we do a significant amount of every year, that doesn't cost the state a dime, that supports people, citizens of Georgia in our communities, I'm using this money to hire investigators. Waste of my time. And it is a waste of resources. It's redundant. No physician is going to admit somebody to the hospital that doesn't need to be there. And the physicians are the ones in charge of admission. So the next thing is that a couple of years ago, the state tried to reduce the cost of care by creating something called the proxy caregivers. And what it did is allowed certain functions of health maintenance to be provided by trained personnel. And we were all for that, absolutely. We think that the cost of certain types of care to be delivered by a licensed medical professional, whereas families can deliver that care at home, such as giving medications, could be handled by trained personnel. We're not saying that everybody that comes through the door can do this, but we recognize that having nurses deliver those or pass those meds is an expensive thing to do in the community, especially when a family is not involved. Well, unfortunately, the proxy caregiver rules, as they became established, became more and more about everything from making sure that people had individual choices of who that proxy would be. So if we have a group home and we have staff and somebody's not there that day, and the person that comes in, if they're not named specifically by that person or that person's representative, that they have the proxy to provide that particular health maintenance activity of passing meds, then they can't do it, and we have to hire a nurse to come in for that day and do that. It doesn't make a lot of sense. The costs associated with that particular program are going to be close to $6 million for the provider community across the state of Georgia, because of the requirements for managing the proxies. One of my points to the healthcare facilities regulations was, I'll just put every employee I have on the back of their proxy. So I have 200 employees that do direct care. Everyone is going to be listed, because if somebody's not there that day and I need to find somebody that can pass meds, because I have to have somebody there, and they're not listed on there as their proxy, then I'm in violation of my license. So it gets to the point where we're really struggling to do the good job that we intend to do here. We raise for my organization, we raise about 5% of our budget through charitable donations. Don't like spending it on administration, and neither do my donors. They want to see us deliver charitable care when we get our donations in, and that's what we intend to do. But when the state costs more every time I turn around to deliver the services, it doesn't make a lot of sense. We think that one of the ways to combat this type of excessive policy making, and that's what this is almost a knee-jerk reaction. Okay, this didn't work, so we're going to write a policy around it. Okay, this didn't work, we need another policy. Is to take and say, okay, you need to do two things. You need to have a public input process on this of some sort, so that the public can say, hey, have you thought about this unintended consequence here? And then the second thing is that they need to tie it to a fiscal note. What is the anticipated cost to service delivery or services or as a result of this policy? So that we don't have this open-ended promulgation of like policies that come out. Oh, it would make a good idea. Let's do this. And it happens. I mean, it's easy to do. To say we just need a new policy. I have a director of quality assurance, and she's constantly telling me that we need a policy for something. And I constantly tell her, no, sooner or later common sense has to take effect. Because you cannot dictate policy and procedure.
Yeah.
You cannot dictate policy and procedure for everything that might happen. Common sense, that's what it's about.
That's why you have kids in schools getting Pop-Tart guns.
We're again. Well, and I don't mean to stop you, but if you are, I'd like to open this up for questions. And
Sure.
if you got more testimony, please give it. But I'd like to open this up for questions from the committee. And if you've got a question, your button. Representative Pizzo.
I know this is going to be kind of anecdotal without any hard data to back it up, but what percentage of your budget is you chasing these ghosts every year?
Last year we actually did a cost study on what it was costing us to do the training around the expectations for our staff to know the policy and procedures, and it really ran my organization about $150,000.
And how many additional people could you help serve with that?
For that, I could do 3 people in residential services, and that's a lot. I mean, that's people with significant behaviors or medical needs. And so that's a...
What's your total budget, though? I mean,
My total budget, I'm not a small business anymore.
Yeah.
I'm 13 years old, and I have a $20 million budget.
Good for you.
So you talk about the spirit of entrepreneurialism, I know what that's about. I just chose to do it as a nonprofit.
no, and that's fine. But I want to make sure we're getting relative terms. Which $150,000 period is not.
It's a lot.
It's not immaterial.
It's a lot.
Right?
That's it.
Any other comments or questions from the committee? All right.
I appreciate the work that you've
Let
done.
me ask you again: the departments that are agencies that are that you're answering to.
Department of Community Health and Department of Behavioral Health and Developmental Disabilities.
Okay. And again, I do remember your stack of papers. So
It's hard to forget that.
Yeah. No, that was unbelievable. My question is, obviously they sort of like pushing the peas around the plate, you know. So there really were no removal. There was no lessening of the regs. They weren't rewritten, condensed. They just tried to push it off in a format in which you could not tell the volume.
It was disingenuous on their part.
Okay.
And that's the problem. And so now there is a legitimate request for proposals that has been put out there. We read that. It's not something my organization is interested in trying to direct. But the fact is, to be honest with you, if you've got these people that can make these policies up there, don't you have the staff already that can trim them? Somebody needs to figure that out. And that's what really, you know, in my organization, when we have policies, we have sunsets on those things. You know what? We can't keep on developing these policies. We have every 3 years, we have to review every policy to see, does this still make sense?
Yeah.
And that's how it's not going on. So we have this, let's grow.
Yeah.
And so I think there's a lot of things that I would do differently just from a simple systemic kind of plan. look for public comment on policies. Tie a fiscal note to it. Create a sunset so it has to be reviewed by X date so that they can't keep it going without that authorization, reauthorization of that process. It makes a lot of sense, and it would help matters. It wouldn't be that difficult to implement a process for that.
Thank you. One more, well, we got two more questions. Representative Stovall.
Thank you, and I want to thank you for the work that you do for individuals with developmental disabilities. Actually, I have a son who has a learning disability, and one of the questions I did have with your organization is, do you all have a lot of issues dealing with work-related issues with dealing with developmental disabilities with your organization, or kind of, I guess, give my background of exactly what do you all end up handling when you're dealing with those individuals?
The type of people we work with, we take on a lot of the more challenging individuals that the state citizenry has. Kids and mostly adults, to be honest with you. People with autism, severe behaviors, aggressive, some people with co-occurring disorders, so they have schizophrenia as well as some sort of developmental disability as well. We do have some employment for some of those folks. It takes some time. But yeah, you know, I sympathize with the previous speaker about workers' comp. It's a nightmare. It's, you know, we have legitimate injuries too. But we also have those people that show up and say, you owe me something. What are you going to do for me? So, and we get to that. You know, that's part of business, unfortunately. But the work that we do with people with developmental disabilities, we have group homes, we have day programs. These are for adults. We have a small adult children's foster care program for kids who are really significantly behaviorally oriented. But that's just very small. So we serve about 1,200 unique individuals each year, and so.
Yeah, thank you. I was wondering, do you know what of these policies are in response to federal regulations and which ones are just made by the Department of Community Health?
You know, there are what they call CFRs, the federal regulations, and a lot of time the state doesn't even look at those when they develop their own policies. So the majority of these are, well, every policy is intended to be safety and health conscious. Yeah, I mean, that's the whole crux of policy. So,
Real quick for the members, CFR meaning?
it's something federal regulations, catalog of federal regulations.
Crazy federal regulations.
Yes.
Okay. I'm sorry. Go ahead with your. I didn't mean to interrupt you. Go ahead.
But there are some of those that, you know, and then the Department of Justice, when it comes in, it likes to swing its sword and stick and strike anybody within distance. So, the state or the providers. And so we recognize that these policies are around safety and health issues, but they go beyond that. You know, I think they're well-meaning, but they just don't ask. They're patriarchal in its model, which is we know what's best for the people in our communities. And I think that's where this feedback. So from my understanding, the feds kind of stay out of a lot of this, and it's really driven by the state's desire to keep its citizenry safe and healthy.
I'd like to point out that most likely there's never been a policy written in the history of this country that has bad intentions.
That's exactly right. It's the unintended intentions.
Yeah, and I just wondered. I know I was in healthcare for a long time, and I know that many times what the state issues, they have to because of the overriding federal regulation. And I just wondered if you knew where the breakdown was. That's.
I believe that a lot of these are a result of policy by newspaper, which is you have a knee-jerk reaction to some story that's generated. I know that in 2001 there was something called Dying in Darkness, and the result of that was a 17-page policy around how deaths are going to be investigated by the state of Georgia and providers and how they had to be reported. That's been trimmed down over the years because it was redundant with a lot of other things that were already in place. But it's still, I think it's about 8 or 9 pages. So.
Yeah. You bring up some great points, and you know, I don't want to blame it all on the representatives here, but over the years, somewhere, this body or the legislature has probably enacted a law that somehow has given authority to these agencies and departments to do what they're doing. And that's where I think we need to go back as a committee and start focusing in on, did we give an open-ended, a blank check to folks to do things? Your testimony is certainly one. I know that we had with decal, I think it is. I've had some issues last year, and it just seems like what you're talking about. It's we know best, and we're going to keep doing, putting out things that we want you to do. And I sometimes wonder, has the legislature given them a blank check, or did we go in last year and tell them to do something? And I think that's something that we as legislators need to be very cautious of what we're doing. I think sometimes we are flippant in what we're doing, and bills and laws that come out of here, and we sort of want somebody to do something, but we turn it over to the agencies to write the regs and sort of keep up with it. So I think we take some responsibility, maybe not individually, but as a body. But that's something that I'd like for us to focus on. And I tell you what, this sort of segments into, and Whitney, I don't know if you're, well, we got one more question. We'll Representative Braddock, and I want to sort of wrap this up, and then I want to sort of give the committee some direction of where we're going to go. Representative Braddock.
Mine was actually more of a statement than a question, but I think that, one of the problems we have is that, we set the guidelines and, here's what we want you to do, and then the agencies are responsible for implementation and rolling it out, and then when budgets get cut, there's a lot of job justification that goes on in trying to, justify what they're doing in these regulations we've set. So, and when you have to report to 2 or 3 different departments, it, I'm sure, becomes a total nightmare because of the overlap and the overreach and the, if you've got 3 departments trying to justify their existence, then they're going to put a lot of requirements on you because they're all trying to justify their jobs existing, and so therein lies the problem with big government. But anyway, I just wanted to say that. So.
Whitney, any more comments? Again, anything that you can give this committee that would be, and again, I want to, as this committee draws people in and we talk to people, we've got to start getting specific. I think we all are in consensus that in general we've got an issue, but this is going to be a real big task, okay? And it's not only the agencies you're dealing with, it's we got the public health issues we just heard. This goes across the board. And as this committee hears from people and looks at the issues, we need to get very specific. In other words, what is the agency or the department? What is the law here? What is the rule and reg, so that we can start getting our hands around some more of the detail. And anything that you could give us, Whitney, would be great as to where to start with these. I know we've got concepts, and that's one thing that this committee is going to do. And with that, I want to segment into some direction that the committee is I think it's going to head this summer. After speaking with the speaker and again, this is a big project. But look, it's pretty hard for folks to come up here. We've heard 2 presenters, Melody and Whitney. Y'all came up here today. But it's hard for people to take off from their business to do what they do, to come up to Atlanta and do this. We've had good participation, but it's still pretty tough. And so I've heard this countless time and time again. So for this reason, I'm going to work on appointing a subcommittee after this session. And what I'm going to do is set up where we're going to visit around the state, okay? And we're going to start hearing some more of this testimony. And I think what we've heard today is starting to sink in where we're going with. We're hearing specifics, but I think what two issues that Melody and Whitney have brought before our attention lead into what I want to do, and that's this framework that we can come back and apply against all the agencies, okay? As rules and regs are made, or maybe even as we go back and evaluate existing rules and regs. In other words, a policy. Melody talked about things of business of different sizes. Where do we the sophistication issue. We talk about uniformity, or things uniform across the board. These are principles that we've got to start putting together and getting in this framework. You talk about, Whitney, about a great point. What's a physical note? We require a physical note for things that we do here in the General Assembly. What is it going to cost the citizens, our taxpayers? What is the revenue effect? Same principle applies to what you're trying to tell us, Whitney, is what is the revenue effect to the businesses? Okay? That's where I think this framework, we've got to start developing a framework of these principles that can be applied as we go through a rule and reg making process, okay? And we go back and we evaluate maybe old rules and regs to see, like you said, are they valid now? Are they still for a purpose? Are they meeting these requirements too? Because we can keep flailing in the wind with hearing all these concepts and all these things, but until we start developing a principled framework, I don't think this committee is going to be able to tackle issues. We may be able to take a small bite out of this thing, just one little bite at a time, but we need to be able to come in with some guidelines and really tackle the broader issues of rules and regs. And so with that, I'm going to work on putting together a subcommittee again that we're going to visit the cities around the state during the summer, and I think again to continue what you guys have done to start hear testimony, so that we can start crafting a framework that can be distributed to the agencies, or we can look to give to the agencies as they promulgate their rules and regs. And state that we want state regulations to be sensible. We want them balanced across the board, and as we've seen, some agencies are good about it or conservative about it, but others take a more activist approach, as we've heard today. If the committee will be on the lookout and the public will be on the lookout, we're going to make an announcement in the next couple of weeks. Okay. But I want to thank our two presenters today for y'all taking your time out of your very busy schedule. I hope you see what we're trying to do and the importance of what you're bringing to us with what you're seeing. And that's what this is new. This committee is a relatively young committee, and this effort is a relatively young effort in relative to this General Assembly. And if we can put together a strong foundation, this framework, I think we'll have a pretty long-term effect and a good effect on businesses, businesses that are trying to make it here in the state of Georgia. So thank you very much, both of y'all. Thank you for what you've done. If you will, make sure your contact information here, and anything that you can give us of detail, Melody, the things we asked, Mark,
Absolutely.
I would appreciate it.
Okay.
So, with that, thank you, members. It's 5:30. I know people have families and other places to be at. Thank you for your participation. Thank you for listening to the folks who've taken their time to come up here. And we're adjourned.